the decision whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under considerations, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether at least it's as my learned senior, Honorable Mwite, has anything to add.
My lords, your leadership, we appreciate that this honorable court of his own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair accusation. Thank you.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law. Therefore, we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Mwite, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. Thank you.
My Lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to immediately after this. I'm most of that.
My Lords and Your Ladyship, further to that, for Senate, I wish to state, my Lords and Your Ladyship, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is it the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My Lords, Mr. Kipe has talked about the gallery of Paul Mwite Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to engage? Do we need to engage in arguments on that? I
will withdraw that. But my Lord, we are ready to proceed. 30 minutes.
You don't
Stop exciting.
something and then you say you withdraw it. You don't start causing the damage.
I will withdraw the remark that the petitioners are addressing the public gallery today.
My Lord, my Lords, with your permission, my lady, yesterday we were barred from being part of these proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you. Our files, there is petition 5E570, E550, E541, E572 that are supposed to be before you. That we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Mwite, and the ones made by my learned friend, Senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my learned friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice so that the court may refer to the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which your lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My lords, may it please you, I hate to interrupt, but this is most unforeseen. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship,
My lord, if I may, my lord. There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
yeah, Your Lordship.
Can counsel on this side be heard?
Yes.
Counsel on that side appears to be taking the whole afternoon.
Because there's
Please,
just speak, Mr. Mwite. If you want to be heard, just speak.
my lord, I'm asking for equity of arms. Accord time to counsel on this side to address the court.
You also just stand and speak.
Let me stand and speak, my lord. My lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling you've read, the question that they wanted was the application for the validity plus the issue to do with the recusal be heard together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending. Are they 3? Actually, I know I'm about to. 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition heard as of yesterday. And we kept on saying yesterday, the petitions to be heard. My lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number 1. Issue number 2, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimotho, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situations where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the enforcement of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice.
Yeah, and Your Lordship,
we want to talk about that.
Your Lordship, the question that
I will
was
talk about that notice before you speak.
My lord, do I have your permission to address the court?
Even if the court wants to talk to you,
The judge is talking.
Dr. Kamima, let me